Next case set for argument is Lopez versus Sarah Hulbert. It's case number 29309. Sarah Hulbert has waived argument, so we will just be hearing from Mr. Lopez, who is appearing pro se today. Sir, you'll have 15 minutes to present your argument. We read the briefs, so we are prepared to proceed tomorrow.
Okay, thank you. Good morning. My name is Mr. Lopez. I'm the pro se litigant in this case. So we're here today in regards to the trial court granting summary judgment to the defendant, Mrs. Sarah Hulbert. I'd like to address a few of the issues. One of the first issues is that the summary judgment was improper to grant because the discovery was not complete. This ruling was laid out by the Sixth Circuit in Brooks versus Vision Wheels Incorporated, in which the court stated that it is well established case law from previous decisions that a non-moving party must receive a full opportunity to conduct discovery in order to respond to a motion for summary judgment. I had submitted numerous admissions and interrogatories that were never properly answered. I filed a motion with the court under the previous judge, Judge Jason Wells, for a motion to compel. He denied that motion. Subsequently, the previous judge that took after Mr. Wells did not grant it either. And then the defendant, Mrs. Hulbert, moved for summary judgment, and they granted her summary judgment. So based on that alone, that was improper to grant her summary judgment when there was still an issue with the discovery that I was never afforded properly. In addition, I never got a chance to depose Mrs. Hulbert, in which this court has copies of the emails between me and Mrs. Barnoff, Mrs. Hulbert's attorney, where I was trying to establish a applicable time and date convenient for them to establish that. They never gave me the date, and then the time ran out. So therefore, I never got a chance to fully involve the discovery material. The second issue that I wanted to address is I filed a motion to strike the defendant's legal expert testimony by Mr.
Don Hicks.
Hmm?
Don Hicks.
Don Hicks, yes.
That's okay.
Mr. Don Hicks. In following the motion, Mr. Hicks in his testimony, there was a few issues that I'm just going to address, and I'm going to address them all. One of the issues is the issue about the appellate issue. As this court is aware, I argued that Mrs. Hulbert never secured my right to appeal. She never asked for a notice to appeal. She did nothing in regards.
And you pled guilty, though, right?
I agreed to plead guilty. The offer was by the government 2 years probation in exchange for the guilty plea. Subsequently, upon the date of sentencing, Judge McCarty decided not to go with that. This is through the 6 months, in which, as the transcript shows, I vehemently disagreed with, and we had an exchange in regards to that, and I had attempted to take the plea back. She said it was too late. In any case, Mrs. Hulbert never secured my right to appeal. I'm going to address that probably last with the case of Garza versus Ohio.
The only reason I'm bringing this up is I'm trying to ascertain with the criminal case that you file a motion to vacate your plea.
Did I file a motion to vacate the plea?
In the criminal case.
After I was sentenced to the 6 months, I attempted to file a notice of appeal with this very court, but it was late.
Okay, so that's what I was just saying. So you didn't file a motion to vacate the plea.
Yes, I did. I filed a late notice of appeal with this
Right,
very
but
court.
those are different,
Oh.
unfortunately. It gets so confusing, I know. Those are just different. And then, and you pled guilty, so there were just a few things that you could really appeal when you plead guilty. And some of it is regarding to your actual sentence. But if you plead guilty, there's just a lot of things that you waive. So that's what I was trying to get at, what was going on in the underlying case that this is arising out of.
Right, and I'm aware of that because this is the second time we're here on this case. And I know the court had asked me about the issue of the appeal, and I was going to address that last. But there's a case called Garza versus Ohio, where Judge Sotomayor, she addresses this issue about appeal waivers and notice of appeals. But moving back to Mr. Hicks' expert testimony that he submitted that I asked the court to strike based on numerous reasons. One of the reasons was on page 6, paragraph 1 of Mr. Hicks' testimony, he states the following: Lopez alleges that Attorney Hulbert did not secure an appeal. However, there is nothing on the record to indicate that Lopez wished to exercise the very limited appeal of the minimum sentence. He said the 9th District Court of Appeals already determined this issue and found no errors. This court didn't address that. It never got addressed. There was the appeal. I don't know why he would tell the trial court that. So his expert testimony is indicating to the trial judge that y'all already discussed the issue.
Will you read that last sentence that you said again about being addressed?
Yes, the last sentence says, the 9th District Court of Appeals already determined this issue and found no errors. That is on page 6, paragraph 1 of Mr. Hicks' expert testimony. Y'all never addressed it.
The only thing I'm wondering is, because a lot of times in appellate cases, you'll argue to the judge, well, the 9th District's already addressed this issue. Maybe not in your case, but when we address an issue, that just doesn't apply to the case in front of us. That applies to the whole law in our district for Lorraine, Wayne, Medina, and Summit counties. So I wonder if he was trying to say that. It's not just the individual case. We don't decide, we're not a trial court, we don't decide just individual cases. We decide what the law on a particular issue is going to be for the district.
Okay, I understand.
I just want, I don't know if that's what he's saying. I have to review everything, but I'm just wondering if that was perhaps it. You don't have to agree or disagree, I'm just wondering.
Yes, point taken, and we're just going to go back to me addressing it using the case Garza versus Ohio, because I do see that there's this issue about appeal. I never heard the term limited rights of appeal until I came to the state of Ohio. I'm from New York and New Jersey. The other issue, well, so moving on to now, in the case Garza versus Ohio, Judge Sotomayor had addressed this issue, and I think that the issue was whether a person has an appeal that has merit. Usually it's to be determined later by the appellate attorney, not usually by the trial attorney. And so she stated in quote, in Roe versus Flores Ortega 528 U.S. 470 2000, this court held that when an attorney's deficient performance causes the defendant an appeal that the defendant would have otherwise pursued, prejudice to the defendant should be presumed with no further showing from the defendant of the merits of his underlying claims. This case asks whether that rule applies even when the defendant has, in the course of pleading guilty, signed what is often called an appeal waiver. That is an agreement foregoing certain, but not all, possible appellate claims. We hold that the presumption of prejudice recognized in Flores Ortega applies regardless whether the defendant has signed an appeal waiver. Also, in the case of Garza versus Ohio, they stated that, quote, this case hinges on two procedural devices, appeal waivers and notice of appeal. No appeal waiver serves as an absolute bar to all appellate claims because a plea agreement is essentially a contract. It does not bar claims outside the scope. And like any contract, the language of appeal waivers can vary widely, leaving many types of claims unwaived. A waived appellate claim may also proceed if the prosecution forfeits or waives the waiver of the government or if they breach the agreement. Now, I wanted to stop there about the breach of agreement. As I stated, as was related to me from Attorney Hulbert, the offer from the government, which would be the state, the prosecutor, that I will receive 2 years probation in exchange for the guilty plea. Based on that, that is what induced me to agree to it, and so therefore I did that. I am aware that that the court has the discretion to accept the plea or not accept the plea. So I believe the question arises that if the court is not going to accept the plea agreement or honor the contract between the defendant and the state, should the defendant have the right to withdraw his plea? In the federal court system, they do allow that. I understand the federal court and the state are different, so therefore, that's a case, that's an appellable issue. That is an appellable issue. And there have been courts that rule that in Santiago versus New York, that the defendant should have the right to take his plea back. If the court's not going to grant the sentence. Also, the court noted that the filing of a notice of appeal is purely ministerial task that imposes no great burden on counsel. Flores, Ortega, 528 U.S. at 474. Following requirements reflect that appellate experience.
Mr. Lopez, I was going to ask you a question. When I was a trial judge, one of the things I did when I was accepting a plea was I would say to the defendant, as part of the plea colloquy, when we would explain the rights and they would decide whether they're going to plead guilty or not, I would explain to them, that I don't have to go by the state's recommendation. I can do whatever I want to on the sentence under the law. Do you still want to enter a plea of guilty? Do you recall language like that?
I believe I do recall language like that.
Thank you.
And as me, because unfortunately I had other interactions with the court system, so my understanding of when we take pleas comes based out of the courts out of New York and New Jersey, and that's never happened. Usually if the state and the defendant agree, the only time the judge will not go with the plea if the sentence is illegal. I've never seen that before, so therefore, based on that, I didn't assume that it would be any issue. However, the issue did come up, and so therefore, I believe that I still had a right to have it reviewed by a higher court, which the appellate court, the Supreme Court of Ohio, and any other courts if need be. Because as I stated, there is case law in regards to taking a plea and the court not agreeing with the plea and not agreeing with the plea. And therefore, I do believe that I still, but at bare minimum, I believe what Judge Sotomayor was addressing is just a ministerial tact that the attorney should have at least file a notice of appeal to reserve the right for the next attorney. If an appellate attorney would have been granted, then he or she could review that and could have proceeded on. She didn't even file a notice of appeal. They said it's a ministerial task.
Did you file a motion for a delayed appeal?
I filed a motion for delayed appeal once I was shipped to Lorraine. So unfortunately, I don't know if this court's aware, but the jail that y'all have in Summit County, in my opinion, based off the prison I've been to, they don't have really an adequate law library. So I couldn't file a notice of appeal. I can't go to the law library. I had to wait till I got to Lorraine, and that's why this very court denied me delayed appeal. However, if my attorney, Mrs. Hulbert, would just file a notice of appeal, I whispered to her to file a notice of appeal, and even if the argument was I didn't, this court read the transcripts. This court heard me, it's in the transcript, I said I wish to take my plea back. So if that's not an indication that I would like to appeal, I don't know what would be. I attempted to take my plea back, Judge McCauley denied it. And therefore, and my attorney, so at bare minimum, that is negligent. Mrs. Hulbert is a smart attorney. She runs the mock trial program. She knows the law better than I do. I don't know why she did not just merely exercise my right just to do the notice of appeal. I mean, of course, there's other issues that I raised as far as being negligent, but I just wanted to address those two major ones because the appellate thing is a constitutional issue under the 6th Amendment of right to an attorney. So, yes, and I think that's pretty much it. Unless I have any questions.
Anything else, Judge Meyer?
All right, thank you for appearing today and for your argument, Mr. Lopez. We'll take the matter under advisement, issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. And the Supreme Court of Ohio's website also has the opinions posted there as well. But thank you for appearing today and for argument.
All right, thank you.